Hello, everyone. Welcome to our webinar on the vaccine mandate. I'm Michael Payne. I'm the chair of our firm's federal practice group. And joining me today is Jeff Jacob, another attorney on our team who is very up to date on all the ever-changing requirements. I have Casey McKinnon, who's a partner in our Washington, D.C. office, who also will be making part of the presentation. And John Landesman, who's a partner from our labor and employment group, who is the go-to person for us on any of the labor and employment issues. And naturally, there is a mixture in this topic of federal contracting issues and labor and employment issues. The reason we decided to put this program together was because we have been inundated, and it's quite understandable, with questions from our clients about what is this all about? What do we have to do? What does it mean? And we are going to address, what this mandate is all about, what you have to do to be in compliance with it, and what can happen if you are not in compliance with it. One of the things that I've noticed over the years practicing federal government contract law is that the federal government uses government contracts to implement social policy. Done it for years. Anything from anti-discrimination to affirmative action to environmental policies, you name it. There are many, many clauses that implement social policies that otherwise would have very little to do with the government contract itself. Well, this is just another example of it. Obviously, the pandemic is of great concern. The government wants people to become vaccinated, and they've decided that one way that they can force it and do it is through what is this vaccine mandate. So we're certainly not going to impose our personal positions on the validity of the program or pass judgment on anyone who is for or against vaccination. We're just going to tell you what the rules are so that you'll know what happens if you get involved with a federal government contract. I'm going to ask that you submit questions, and feel free to in the question box on the screen. All of the participants are muted, and the presentation is being recorded, so you won't have to worry about taking too many notes. It'll be available to everyone who is interested. And with that, I'm going to turn the first section over to Casey McKinnon, who's going to address the origin of the mandate and what it all means.
All right, thank you, Michael. So as Michael noted, I'm going to be addressing the nuts and bolts here. What exactly is required, the who, what, where, when, why of these particular requirements. And because this all came to be in a somewhat unusual fashion, it's helpful to step back and look at the timeline and the steps that got us to where we are today. So this all started with an executive order issued on September 9th of this year, which gave rise to the Safer Federal Workforce Task Force. You're going to hear a lot more about that task force today. Task force issued guidance on September 24th, which led the FAR Council to issue a class deviation, and new FAR and DFARS clauses were created at the end of September. And then those clauses start finding their way into new solicitations, new contracts, and in many cases, existing contracts moving forward. So the executive order isn't the most important document at this time, but it's nice to know a few things about it as we move through our presentation. So at its most basic level, it called for federal contractors to comply with any guidance issued by the task force. It directed agencies to create new clauses that mandated compliance with the task force guidance, and it led to the creation of new FAR and DFARS clauses. And that's really all you need to know about the executive order at this point in time. Moving on, we move to the task force. And what you're looking at here is a screenshot from the task force website. Now, the task force put out what I would call their base guidance on September 24th. But in addition, the website contains a FAQ, frequently asked questions section, which is probably the more important aspect of their guidance at this time. That FAQ section is updated on an ongoing basis, usually once or twice a week. And not everything is simply questions being answered. In some cases, there's additional requirements or clarifications or detailed explanations as to how this is all supposed to play out. So for any contractor that is concerned about or subject to these rules, monitoring that FAQ section is very important. one note, stepping aside from the FAR requirements at this point in time, this is not a government contractor specific requirement. So all covered contractors are required to have a COVID-19 safety coordinator. This is a rule from the OMB, Office of Management and Budget. And that's an individual designated to coordinate and manage your COVID-19 workplace safety efforts. It's likely you have someone serving in this role already in reality, but it's important that every company make sure to designate someone with this particular title. It's not a standalone role. It could just be another hat that person wears. But in case anyone ever came to ask who your safety coordinator was, you'd be able to point to the relevant person. And now we'll get to the new clauses. It's important to note one thing as we get started here, and it's these requirements do not apply to government contractors as a general principle. They apply on a contract by contract basis, and only when a particular clause, whether a FAR or DFARS provision, is inserted into either a prime contractor's contract with the government or a subcontract underneath the government contract. So unless that clause is in the contract, the requirements themselves do not apply. A few things to note about the FAR clause. It says very little. It tells you it applies to contracts in the US and the territories. It states that the contractor shall comply with all task force guidance, including future updates to that guidance. So this is a living, breathing FAR clause. As the task force website changes, and that guidance changes, so do the requirements that would apply to a contract. And finally, it requires that contractors flow down the clause once it's inserted into a contract to lower tier, either first or lower tier subcontracts that are in excess of $250,000, unless those subcontracts are merely for products. So if you're in a case where a particular subcontractor is only providing materials or particular, especially commercial off-the-shelf products, there's no need for the contract to be flowed down into that agreement. In terms of when and where you're going to start to see these clauses, it's to be inserted into all contracts and contract-like instruments. At a fundamental level, if you hold a federal government contract, you should anticipate seeing this at some point in time. Contracting officers must incorporate the new clauses into new solicitations and awards, as well as options that are exercised, and then extensions or renewals of existing contracts beginning on October 15th. So that process has already begun. If you're bidding on new work, you should be expecting to see this. But agencies were also encouraged to incorporate the clauses into existing contracts. And obviously that's not a mandated or directive, but we've seen quite a few agencies be fairly proactive and aggressive about modifying existing contracts. And Michael will get into, in his part of the presentation, what to do if that does happen in your case. So now we'll get into the task force guidance. As I alluded to, all the FAR clause tells you is to follow the task force guidance. So once this clause does end up in a covered contract of yours, the question that many contractors have is, how do I identify which of my employees are actually subject to these requirements? Because it's not all of your employees, and it's going to be on a contract by contract basis. There's a two-step process to follow to identify all the covered employees. Step one is going to be identify your covered contractor employees. And that's all those working on or in connection with the contract that includes the clause. That term is defined very broadly, especially the in connection with portion. So an employee doesn't have to be hands-on working on the particular contract. It can be a more indirect level of work, particularly back office work. So it's encompassing HR work, billing, accounting, legal, and remote work. Anyone whose job duties in any way interact with that contract, those people are covered contractor employees. So that's your first step. Identify that pool of covered contractor employees working on or in connection with the contract. Your second step is the one that's been a bit more confusing in reality, is to identify your covered contractor workplaces. And in effect, a covered contractor workplace is any location where a covered contractor employee, so someone from that first group, is working or is likely to be present during the time of this contract. So once you've identified all the individuals who are covered, you need to identify all your locations that are covered. And that's any place where someone from the first pool is either working or is likely to be present during performance of the contract. And a question we've gotten often is, does that mean a single employee working in connection with a contract could subject an entire building or office to the requirements? And the answer is yes. So for most companies, this has meant that your home office is almost assuredly covered by these requirements, so long as there's a single person there who might be working at HR or accounting and who interact with this contract. The only exception, this is very difficult to actually qualify for, is if you can establish that either a separate building or a separate floor has no interaction with the covered contractor employees. So if you have a contractor employee on floor 7 working on a particular contract, and you can establish that no one in floor 8 ever crosses paths with them, parking garages, elevators, hallways, then the floor 8 employees wouldn't need to comply. Again, very difficult to qualify for, but important to note. So just to circle back, because this is probably the most complicated part of the base requirements, to identify the covered employees once the clause is in a contract, first you identify all the employees working in connection with the contract, then you identify all the locations where those employees are working or are likely to be present. And if you're in the first group or at a location from the second group, you must comply. How can an employee qualify or comply with the mandate? So the question is, now that I've identified who, what do these people need to do? And the answer is, it's not quite a vaccine mandate. And we'll get into this more later. An employee must either provide proof of vaccination or receive a medical or religious accommodation. So it's not to say that every employee must be vaccinated. It's vaccinated or medical or religious accommodation. But to clarify, there is no way to have weekly testing or other measures to exempt yourself from having either proof of vaccination or the exemption. It's got to be one of the two. Timelines. Employers must see proof of vaccination by January 4th or the first day of contract performance if we're dealing with a new contract. And an employee is fully vaccinated 2 weeks after their final dose. And I'm going to turn this over to Jeff in one moment, but one other caveat that's important to note here, we've also gotten a lot of questions about the interplay between the FAR and DFARS requirements and the new OSHA 100 employee or more requirements. The language in OSHA's rules is not entirely clear, and hopefully they'll clarify this moving forward, but our read at this point in time is if any of the employees, or so if you're an employee or a location where the FAR or DFARS requirements apply, OSHA does not apply there. However, if you have other locations or employees that are not covered by the FAR or DFARS requirements, those employees and locations will be subject to the OSHA rules. And with that, I'm going to turn this over to Jeff, who's going to talk about some requirements that go beyond just vaccinations.
All right, thank you, Casey. So yeah, one thing that's important to remember is that there are requirements other than just being vaccinated that gets kind of overshadowed with all the focus being on the vaccines. But there are these other masking and distancing requirements, and these are going to apply at your covered contractor workplaces, which Casey talked about earlier. Basically, anywhere where people need to be getting the vaccines under this mandate, there are also going to be these other masking and distancing requirements as well. So the process is a little bit cumbersome of figuring out and implementing these masking and distancing requirements based on the way that the guidance set them up, but there is an easy way to simplify them. So we'll walk through all of that. The first thing you need to do under the guidance is you need to check the community transmission rate for each covered location. So if you have, and it's based on county or counties in different states. So if you have 3 different locations in 3 different counties that are all covered by the mandate, then you're going to have to check this for each of those locations. And what you'll see on the screen here is a screenshot that I took of the the COVID-19 data tracker from the CDC, which is where you go to check each week. You're supposed to check this to find the community transmission rate for each location. And this is what it looked like for Philadelphia. You'll see the red dot there that indicates that the transmission rate was high. And then, so there, and actually it'll be one of 4 levels, low, moderate, substantial, or high. And you'll see here that it was high for this particular week. So once you have that information, then the question is, what do you do with it? So the first thing is that for counties that have substantial or high transmission rates, if we can go to the next slide as well, then for vaccinated individuals, There are no distancing requirements, but they're going to need to wear masks in communal indoor spaces. So your elevators, your hallways, cafeterias, things of that nature. Unvaccinated individuals, the requirements are a little stricter, not surprisingly. One is that they have to physically distance, which is defined as 6 feet from other people to the extent practicable. And that applies both indoors and outdoors on your sites. And they are also supposed to wear masks indoors in all locations, not just communal areas. And then also unvaccinated people are supposed to wear masks outdoors if they can't distance. So if they're in a crowded area outdoors. For areas with low to moderate transmission rates, unvaccinated individuals have no masking or distancing requirements. Unvaccinated individuals, you'll see here, it's actually the exact same requirements that we just looked at for high to substantial to high transmission rates. So really, with respect to masking and distancing, nothing is going to change for unvaccinated people. You have the same requirements: physically distance to the extent practicable, wear your mask indoors, and also wear your mask outdoors if you can't distance. The only thing that changes is whether or not vaccinated individuals have to wear their masks in communal indoor spaces. So what we've been suggesting as a way to streamline this, because keep in mind, these are minimums, right? You can always implement a policy that's stricter than what these masking and distancing requirements are. So what we've been recommending is if people want to streamline it, you can just set it to the highest levels, since the only thing that changes is whether or not vaccinated people have to wear a mask in certain indoor spaces. You can kind of set it and forget it. You're covered that way. Then you won't necessarily need to be checking every week and adjusting, your policies and going through that administrative burden. With respect to exceptions, there are a few to the masking and distancing requirements. They're based on guidance from the CDC, and a few that are specifically mentioned are one being if you're in an enclosed office, meaning if it has 4 walls and a door that go floor to ceiling, and obviously if the door is closed, then it's okay to remove your mask. Same thing if you're working in a location where your mask might get wet, if you're working around water on a boat, something like that, that is another exception. And then the third one I put down strenuous activities, but the idea is really anything where your the nature of your job, wearing a mask could interfere with your ability to breathe. And then finally, there's a kind of a catch-all exception for other health and safety risks based on the unique circumstances of your job or a particular individual's job. If you're going to use the catch-all, then it does require an OSHA workplace risk assessment to be completed. And with any of these exceptions to the masking and distancing, it's not simply up to the individual employees. They have to be approved by the contractor in writing. And then finally, before I turn it back over to Michael, oh, there we go. There are some flow down requirements. Casey touched on this earlier, but the clause needs to be flowed down to your contracts at all levels, with 2 big exceptions. One is that it does not need to be flowed down to subcontracts that are below 250,000, or if there are subcontracts that are solely for the provision of products. So if materials suppliers, component suppliers, things like that, they are not subject to the flow down requirement. And then finally, before I turn it over to Michael, and he'll expand on this a little bit, but keep in mind that the flow down requirement is just that. Just make sure you get it in the contracts, and most likely, hopefully, you won't need to be policing your subcontractors unless it's an unusual circumstance. But I will turn it over to Michael and let him run with that.
Thanks, Jeff. As Jeff just said, the best advice we can give you is your obligation in federal contracts is to flow it down. That means put the clause in your subcontracts. If your subcontracts are amended or modified, and then modify the subcontract, and that's your obligation. You can assume that your subcontractors are in compliance. If a subcontractor comes to you and says, you know, I'm opposed to this vaccine mandate and I have no intention of complying with it, and I just want you to know that, well, then he's created a problem for his company and for you, because you'd have to consider whether or not you can continue to knowingly do business with someone who's given you credible evidence that they are not going to follow the mandate. But there's no requirement for you to collect proof of vaccinations from the subs or certifications. And this is one of those times when I'd have to say, probably from a prime contractor's point of view, the less you know, the better. Now, for existing contracts, the federal government has been encouraged by the guidance, not mandated, but encouraged by the guidance to modify existing contracts by a bilateral modification. And a bilateral modification is a modification that both the government and the contractor sign. You certainly should accept that because the clause is required by executive order, and I don't think you can have any legitimate reason for saying that you won't accept this new government clause. The question comes up, though, about whether or not you have to accept it without the right to any additional compensation. And of course, that's the big question. And the answer to that is no. When the government changes an existing contract, it can only do so under the changes clause. And the changes clause says that a government contractor is entitled to an equitable adjustment of his contract, meaning additional time and additional money, provided that you can back up those costs. And under the federal acquisition regulation, which governs all government contracts, FAR Part 31 says that costs are legitimate if they are allowable, allocable, and reasonable. So if you have allowable costs that are allocated to this contract that are deemed reasonable, those are the kinds of things that you as a prime contractor and as a sub as well can get compensation for from the government. Now, in new contracts, it's entirely different. I'm talking about a solicitation that's out on the street or a new subcontract that you're issuing as you're about to bid a contract and you need subcontractor assistance. That clause is going to be in the new solicitations. So you will not be able to file a claim later and say, well, this clause caused me to incur additional costs. What the government's going to say is, well, you knew about it when you bid the job. So it was incumbent upon you to include any price impacts in your bid price. And of course, I know that this is so new that contractors don't really have a handle on what it's going to cost them to implement this program. But nevertheless, you're going to have to make your best guess and include it in your bid price, because there's a difference between modifying an existing contract and spelling out the requirement initially in a new contract. Now, there are also in government contracting, of course, what are called indefinite delivery, indefinite quantity contracts, IDIQ, sometimes referred to as a MATOC, a multiple award contract. What that means is you're awarded a master contract, which says you're now part of a pool of maybe 4 or 5 contractors who are going to compete for task orders as that work is solicited by the government. Well, a task order is really the same thing as an individual standalone contract. So you may find task orders as they're being issued, being modified to include this clause. If it's a new task order, then include it in your price. If it's an existing task order that's being modified, treat it the same way as knowing that you need to be reserving your right, and I'll explain how in a minute, to be compensating for additional costs. Now, sometimes the government doesn't do it in such a straightforward way. Instead of modifying the existing task orders, they may modify the existing umbrella master MATOC contract. Well, you may not incur any costs because of that per se, unless you get task orders afterwards. But just understand that even a modification of the master IDIQ contract does entitle you to compensation should any compensation flow from it, as would any following on task orders entitle you to compensation that are subject to that modified master IDIQ contract. Okay, how do you protect yourself? Well, you may have seen in government contracts what are referred to as closing statements. I hate that terminology. Lawyers refer to a closing statement as something that they are going to deliver in court. The government's decided to call a release in some agencies a closing statement. And unfortunately, some contractors don't realize the illegal effect of it, and they sort of gloss over it and sign the modification anyway. Don't do that, because if you sign something that's labeled closing statement or release or waiver or something like that, what it means is you're agreeing to accept whatever compensation is in the mod, and you waive your right to anything else. And that's going to be legally binding. So you don't want to sign that. Instead, you want to say to the government agency, or if you're a subcontractor to the prime, please remove this waiver or release or closing statement from the mod, because I'm not prepared to waive my rights. And we have found that most government agencies are agreeing to do that. I think it's on their boilerplate forms, and they know that it's something that should be removed. And if they do, that's the end of the problem. If they don't want to remove the release, then say, well, I'd like to be able to reserve my rights. And that means inserting a reservation of rights clause on the modification. We've given you some language here as to what a reservation of rights clause would look like. And if there's something, those words are used or something equivalent of them, then you can go ahead and sign the mod and be protected. We have run into a couple of situations where the government agency has said, no, we're not going to remove the release, and we're not going to allow you to reserve your rights. You need to sign this. It's a requirement. If you want to file a claim, go ahead and file a claim under the disputes clause. Well, that's really a kind of silly answer from the government, because if you've signed the release, you don't have any rights under the disputes clause. So first of all, that just makes no sense to me. But we have seen in a couple of instances, government agencies that have said, if you don't sign it, then we're not going to pay you anymore. We're going to consider terminating you for default. Well, you probably don't want that to happen. So what you should do is you write a letter or an email to the government and say, I have this modification. I've requested that the release be deleted, or I be permitted to reserve my rights, and you've told me that I may not. So I want you to know that I'm going to follow your instructions and sign this modification, but I'm doing so under protest. And what that will do is we'll set up an argument later that, well, under the threat of a termination or not being paid, I signed it under duress. And a release signed under duress is legally ineffective. Hopefully, there won't be many situations where you have to do something like that, but we just want you to be aware that that's one way to protect yourself. So now you might say, okay, well, if I've reserved my rights and there's no release, what are you talking about? What kind of claims can I submit? Well, as I said, it's a change. We've inserted a new clause in a contract that wasn't in your bid price. So anything that's an allowable, allocable, and reasonable cost can be claimed. You can submit a request for an equitable adjustment. You can submit a certified claim, depending on what the costs are. But you might be asking for the cost of supplying masks. You might be asking for the cost of putting some sort of a testing program in place. Probably the most significant costs that you could incur are those that would result in delay or disruption of the project. If the implementation of this program in the field or in your home office or in some way causes you to expend a significant amount of money and disrupts and delays your performance, that is a legitimate claimable item. Okay, now we come up with the new word that I don't think I really had heard before the COVID instance. And of course, maybe it's become identified with Aaron Rodgers, anti-vaxxers. And listen, there is a legitimate difference of opinion in this country as to this vaccine. I don't dispute it. I'm old enough to remember when the Salk polio vaccine was introduced. And of course, that attacked a disease that's called polio, but also was called infantile. And I didn't hear anything about opposition to the vaccine. People couldn't wait to get that vaccine. But times have changed, and that's not the way it is right now. So what do you do if you have an employee who says, look, I'm opposed to this, I'm not going to take it? Do you have to fire them on the spot? Well, the answer to that is no. The rule says that employees must be vaccinated or they must be granted a medical or religious accommodation. What that effectively means is they have a legitimate medical or religious exemption right. And while the task force has provided some guidance on what can be allowed, and you can look at that fact site that Casey identified, this is a dynamic, ever-changing field, and you need to keep up to date on what the latest thinking is. I think that medical accommodations are the easiest ones. I mean, if someone has had an adverse reaction to the vaccine's first dose, or they're allergic to some ingredient in the vaccine, or they have some medical disability or medical reason that dictates against taking this vaccine, that's something that you should accept. You don't need to get into the medical history of anybody and question what the reason is. I think one way they could establish it very clearly is present a letter or a note or a script from a doctor that says, look, so-and-so is my patient, and the use of the COVID-19 vaccine is contraindicated, and I recommend that he not take it. I think that John, who I'll turn to in a second, would agree that it's not your responsibility to call the doctor and say, hey, by the way, where did you go to medical school? Or let me debate this with you. No, I think you accept it because it's a valid medical excuse. And then you accommodate that person, and we'll talk about that in a minute. And you can give them an extension of time. You know, if someone says, look, I didn't want to take the vaccine, but I've changed my mind, and I just had the first dose. It's going to be another 3 weeks for the second dose. You don't have to fire that person. I don't think you would want to. You would say, okay, we're going to extend the deadline for you. You may have to treat them during that interim period as an unvaccinated employee and accommodate them, but you can allow that time period to pass. We know that apparently if people have had monoclonal antibodies or convalescent plasma, the doctors will say you shouldn't take the vaccine for some period of time. So certainly that's something that you should pay attention to. But now we get to religious accommodations and this idea that people are entitled to a sincerely held religious belief. And this is the area that, as an attorney and a member of our government contracting group, I have felt the most uneasy about, because I think it's a labor and employment issue. And there's no one I respect more than John Landesman on those kinds of questions. So John, why don't you just provide some of your thoughts about how this should be treated?
Sure. Thank you, Michael. So when we're talking about religious accommodations, the bar is set very low under Title VII of the Civil Rights Act. Really, whenever an employee comes forward and says that they have a religious belief that contradicts the vaccine policy that the employer has, the employer is required to really presume or assume that that stated religious belief is valid. I've had a number of clients come to us over the last few weeks and say, how can the person say that they're a member of a certain religion and say that they can't get the vaccine because of their religious beliefs, when I know for a fact that the religious leaders in that particular religion are encouraging people to go out and get the vaccine? And the answer is, that's not for the employer to do, to get into that area. Similarly, it's not for the employer to say to the employee, I'm not going to take your word for it. Instead, I'm going to require that you provide documentation from a priest or rabbi or some other religious leader. The employer can't do that. if the employee comes forward and states that they have a religious belief and it contradicts them getting the vaccine, it's pretty much the end of the discussion right there in terms of whether or not the person is entitled to a religious accommodation. You know, the EEOC, and they don't usually do this, has issued a form that they use internally, and they have done that to sort of provide a template to give some guidance to the employer community. And if you look at the EEOC's form that they give to their own employees with respect to this religious accommodation issue, you can see that the questions, and there's only one or two of them, are very sort of open-ended, saying, describe your religious belief, number one, and number two, state how that religious belief somehow conflicts with you getting the vaccine. It doesn't go into any more detail or ask for additional documentation or supporting evidence.
Well, thank you, John. John, while I have you, I should tell you that I've also, on the medical exemption issue, someone asked me, well, what if the note is not from a medical doctor, it's from a doctor of osteopathy? And my answer was, well, that's still someone in the medical profession who's probably in a position to judge that. And I said, you should accept it. Would you agree with that?
I would agree with that. And I wouldn't distinguish between a DO and an MD for purposes of providing medical accommodations. And frankly, we can request more documentation for the medical accommodation than we can for the religious accommodation. But in my experience, as a practical matter, and this isn't just with respect to vaccine-related issues, but when requesting information from employees and their healthcare providers, it's almost always the case that the employee is able to get documentation from a healthcare provider that supports the employee's position, because the employee has a relationship with the physician, it's a family doctor, and the doctors are generally willing to accommodate the employee's requests and give them the note that they think is helping that employee without really regard to what's good for any particular contractor or employer.
Okay, thank you.
Sure.
Now, of course, then the question comes up, well, what if someone has made this request of you and has asked that they be considered essentially exempt because of the medical or religious reasons? What happens if you deny it? Do you then just say, your request is denied and you're fired? I don't think you want to do that. I think you establish a timeline to promptly become fully employed and vaccinated. And maybe give them some sort of a grace period. And John, maybe to put you on the spot for another second, I wonder if you have any further thoughts on how to treat that situation.
I think that, like any other employment situation, making a quick decision and terminating someone quickly can often be fraught with pitfalls and liability. And so I like the idea and would endorse the suggestion here that providing the person with a deadline, giving them that extra chance, it would show and prove to a finder of fact later on, whether that be a judge or a jury, that yes, we were fair with this employee. We gave them every opportunity to comply. And still they wouldn't turn around and provide us with the information or become vaccinated, whatever the case may be. So showing that we gave the person that extra chance, being fair with the person, that's what employment discrimination cases are all about ultimately.
Okay, thank you. And then, of course, the next question is, all right, well, what happens if the request is granted? Do you say, okay, this is a valid medical reason, this is a valid religious reason, I'm going to grant it? That doesn't mean that you can now allow this unvaccinated employee to just run around your workplace or your projects freely and without any restrictions. You know, sometimes I think we forget that the intent of the executive order is to do what we can to spread the disease, to prevent the spread of the disease. And anything that would foster that is contrary to the spirit of the order. So you have to decide, okay, what's the accommodation I'm going to grant? At a minimum, the rules say maintaining physical distance of 6 feet to the extent that it's practicable, masking indoors, even masking outdoors. I have heard that some contractors have said, well, we're going to go one step further and we are going to implement a COVID testing program. Now, the rules don't say that you must, but I don't think that there's anything that says that you cannot. And if you feel the safe way to accommodate your other employees and vaccinated people or people at risk is to have some reasonable testing program, that's something you could do. And the point is, the accommodation does involve some sort of a restriction of the people who have been granted this exemption or accommodation. And then, of course, the last question that comes up, well, what happens if I fail to comply? And what happens if I'm just going to tell the federal government or the prime contractor, I disagree with this. It's a free country. I have the right to choose. My body is my temple, whatever the case might be, and I'm not going to do it. Well, if you as a prime contractor were to say that to the federal government, what you're doing is telling the federal government that you are not going to follow what has become a clause in your contract. And if you don't follow a clause in your contract, you're in breach of the contract. So now what can the government do? Well, they could just suspend you, put you on a suspension of work without pay, no cost suspension. I don't think the government could be faulted for doing that. I don't know that they would do it for an indefinite period of time, but they certainly could do it. They also could take the next step and terminate your contract for default. You've breached the contract. You're eligible for a termination for default. And as a matter of fact, the latest guidance on the website, it says that and uses the very term termination for default. I could see that in a really egregious case where somebody just flagrantly violated these rules in a very egregious way, you could be proposed for debarment. And you may not know this, but if the federal government proposes a contractor for debarment, you are debarred the second you get that letter until you can manage to negotiate or get it turned around. So the consequences are serious from a contractual point of view if the mandate is not followed in a federal government contract. Now, there are going to be big protests on this. We've already had clients who've said, well, how can they just put this clause in a new solicitation? I think it's unconstitutional. Let's file a bid protest. We haven't done it yet. I haven't read any case that's been brought yet of a bid protest. There probably will be some. I'm not so sure that it's a winnable protest because it's not up to the GAO or even the Court of Federal Claims to look behind the insertion of government clause that's been authorized by the executive order. In other words, it might be struck down somewhere, but I don't think it'll be struck down in a bid protest. If you put in a claim for additional costs and the government says, no, we don't think that those costs are reasonable, or we're only going to pay you half, or you didn't really incur them, well, certainly just like any other case in a government contract, you can file a claim and seek the full damages that you incurred. And of course, there are going to be, and there already are, court challenges. About a week and a half ago, 19 state attorney generals filed a suit in federal district court alleging that the mandate is unconstitutional and should not be applied to their states. This could very easily go to the Supreme Court. And if the Supreme Court says that this mandate is unconstitutional and strikes it down, then everything we've told you about today will be off the books. But until that happens, the best advice we can give you is treat it seriously, understand that it is now part of federal government contracting, and act accordingly. Okay, I know we threw a lot at you. I see that some people have made some comments in chat and Q&A, and we're happy to take any additional questions beyond those that are already entered. just let us know what they are, and I'll leave it to Jeff to decide who best to address the questions.
And Jeff, before you go ahead with the ones in the chat, maybe we could run through the pre-submitted questions quickly.
Yeah, that's a good idea.
So I'll try to move through these fairly quickly. One question is, do remote employees have to comply with the rules? The answer to that would be yes, if they are working on or in connection with a covered contract. So if a remote worker is working on a contract that includes the clause, that would apply to them. Does it apply to state and local contracts procured using a federal vehicle? The answer to that would be only where the contract is directly with the federal government at this point, at which time you would see the relevant clauses in the contract. Does it apply only to new contracts? We touched on this. No. In some cases, it's being inserted into existing contracts via modification. We get a lot of questions about, is it only going to apply to employees that go directly to the job site? And as we talked about earlier, no, it extends beyond that. If the contract includes the clause, even home office employees are going to be subject to it if they're working in connection with the covered contract. We had one more question. If a company is selling commercial off-the-shelf products and no physical interaction with government employees, would they need to comply? We touched on this a bit. The answer should be no. If your contract is merely for the provision of products, the FAR clause says that it should not apply in that case. So you'd have a basis to push back. Jeff, I think we can go to the chat now.
Okay. All right. So I'll just kind of run down these questions in order. First one is for those employees who produce a medical release or religious exemption and require an accommodation such as weekly testing, are there guidelines for the weekly testing, and where can employees or must go for testing, or if self-testing is acceptable, et cetera? I'll let John expand on this, but and Michael as well. But the answer, firstly, is there is no testing is not a required accommodation. It's certainly something you can require if you want as part of your accommodation, but it's not a requirement of the mandate or the guidance. So I'm not aware of anything in there that has to do with where employees can or should go for testing, but that's more something that will be up to the employer's discretion. Is that fair, John? You have any comment, or Michael?
Yeah, Jeff, I think you hit the nail on the head. I'm not aware of any requirements in the guidance or otherwise to provide for testing and accommodation, but to the extent that the employer wants to do that, they're certainly at liberty to do so and can establish parameters. And if they're going to move forward with that, they should implement a written policy describing exactly how the testing is going to be reported to the employer.
All right, thanks, John. The next one I'll throw out to Casey. It says, if you are an employer with a single workplace and you have a contract subject to the guidance or the federal mandate, are you exempt from the entire OSHA ETS or just the requirements that affect the workplace, i.e. masking, distancing, and testing non-vaccinated employees on site?
Based on the guidance available right now, if your employer and your only workplace, and therefore assuming all of your employees are subject to the task force guidance, then the OSHA ETS would not apply. That's how the ETS has it written up right now. We'll have to monitor that moving forward. But for now, if the task force applies to all of your employees and locations, then the ETS would not apply.
Okay. Next question says, I have VA contracts and the VA is sending out contract modifications. Can I submit an REA after I sign the modification? I'll let Michael comment on that, but I think the answer is yes, as long as you make sure you don't sign a release when you sign the modification.
Yeah, you certainly have the right to submit an REA, as Jeff says, as long as on a release. But when you say after you sign the modification, the question becomes how late after. I mean, you got to wait to see if you've incurred any additional costs. You're not entitled to compensation simply because the clause was put in your contract. See what happens. Does it cost you time and money? If it does, yes. You certainly don't have to wait till the contract's over. As soon as you start suffering some damages, then you can make a request.
Okay, next question says, I'll come back to that one. Next one, not all of our employees work on our government contracts. The outside employees will come in contact with the contract workers and the back offices. Do these employees also need to be vaccinated? I'll let Casey take that, but I believe the answer would be yes, as long as anyone who's coming into contact with people working on or in connection with one of your federal contracts would be subject to the vaccination requirement.
Yes, because in effect, if you have employees working on a government contract, anywhere those employees work or are likely to be present becomes a covered contractor workplace. So if your outside employees are going to come into those locations, those employees would also need to be vaccinated. So think of it like the employees directly working on the contract are covered. But now that you've identified the locations that are covered, anyone who comes to those locations is subject to the same requirements. Whether that's an employee or even a visitor would be subject to these requirements at those locations.
Okay, next one is one actually that I have not heard before, and I'm going to throw it out to everyone. It said, with regard to who is a covered contractor, it says, what if a private company is a landlord and one of the tenants is a government agency? The agency is seeking to add the clause into an existing lease, asserting that the private company is a covered contractor. And that would require the private company landlord to require all of its employees to be vaccinated or have an exemption.
I'll
rather
take a
than-
crack at that one if you'd like,
Yeah.
Jeff.
Yeah,
So, and on one hand, the government is going to look to incorporate this clause into any direct contract that someone has with the government. If you're looking to push back on the insertion of the clause into a lease agreement, your argument would be that this is not a contract for services. This is a contract for products. There's the Service Contract Act, which some people look to determine whether a contract is for services or not. And this should apply mostly to contracts for services. Explicitly, it says a lease agreement is not a contract for services. So my argument there to push back if the government is looking to incorporate that is that this is not covered here because this is a contract not for services, but instead for products or materials here. I'm just providing a building. You should note, though, that if you're dealing with a workplace where federal employees will be working, whether it's a government building or something you've leased to them, anyone who goes to that location is certainly going to have requirements imposed upon them for the safety of the federal employees rather than reasons of the FAR clause here.
Yeah, the other thing that could come up is if they really get pushy and want to modify the lease. I mean, as a landlord, you don't have a right to file a claim under a release. If you are of a mind to go along with what the VA wants to do, you might say, okay, let's talk about what the new rental value is. It's good for one, is good for the other.
okay, so next question is from a roofing contractor. I'll let Michael and Casey take this one. It says we are a roofing contractor, i.e. not normally working inside the facility, but on top. We have asked for further guidance, but we potentially have a base, I assume this means a military base, that appears they will require our employees to complete a form indicating vaccination status. If unvaccinated, the base is indicating that the employees must provide a negative test within 72 hours in order to gain access to the facility. The testing appears to be above and beyond the requirements of the mandatory vaccination order. Any comments?
I can take this one. It appears those requirements that are being imposed upon you are not a matter of the federal contractor mandate, but instead conditions of working on a government facility. So this summer, the government issued some requirements that if you have individuals, your employees are going to be going into government buildings or into government facilities, they would need to either self-attest to being vaccinated or provide proof of that testing. So what you're seeing is not a matter of these government contract clauses now. That's just a condition of going to the job site itself. That's not to say you might not have a claim, but it's just a different implementation mechanism here. So it would only apply to those people going to the base, but there would be a basis for imposing that requirement on you.
Okay, next question. We're getting so many that I'm losing track here. says, what if you refuse to sign the amendment to an existing contract? I assume they can terminate the contract for convenience, but it doesn't seem like a breach or debarment would apply. You have any comment for that, Michael?
Yes, well, if you refuse to sign, it would be a modification to the existing contract. What they could do is issue it unilaterally, because they're encouraged to make it a bilateral modification, which means you would sign. But if you refuse, my guess is the government agency would say, okay, we're inserting the clause unilaterally, here it is. That means you're bound to the clause, but you also would retain all of your rights to file claims because there's no release in a unilateral modification. So I think in the real world, that's what would happen. I seriously doubt that they would terminate the contract for convenience. And certainly I would agree that a debarment would not apply simply because you refuse to sign the modification. Now, if they made it a unilateral mod and you said, hey, I'm still not doing this, I'm not going to agree to this unilateral mod, you can't force me, then you'd be risking a termination for default and or possible debarment.
All right, next question is for John. What if you were, or no, sorry, what are your suggestions for the proper collection of proof of vaccination so we aren't violating any HIPAA laws? And does the info go straight to HR or somebody else?
So the EEOC has issued guidance and Q&As dealing with vaccine policies, and has specifically said that an employer can ask an employee about their vaccination status, and can also ask for documentation, which typically is furnished in the form of either the employee showing the actual card to the employer, or showing an image like a picture or scan of the card. And so, you know, the employer can collect that information. Generally, like any medical related information, it should be centralized. Best to centralize it with the Human Resources Department. And of course, just like any other medical related information, we don't want to just put a copy of that card in the employer's personnel file. Employers should keep separate files that have any medical information for each employee. So it shouldn't get mixed in with the general personnel file.
Okay, thanks, John. Next question says, our organization performs electrical work in a VA hospital as a subcontractor to a prime contractor. Our typical contract value is less than 200,000. Are we exempt from the order? The answer to that would be, well, it's on a contract by contract basis, number one. So, but if your contract is less than 250,000, then the only thing I would say is that your prime contractor is not obligated under this order to flow down the requirement to you. They could still flow it down if they choose to. And also there could be separate requirements, given that you're working at a VA hospital that's a federal site, there could be separate requirements, you know, for accessing that site that have nothing to do with this order. The next question says, just as a point of clarification, the question asks that says the original requirement was that this would apply to companies of 100 or more employees. If a contractor has less than 100 employees, does this still apply? It sounds like there's a little confusion there. We're talking here about the federal contractor mandate. The 100+ employee mandate is the OSHA one. So those are two separate things.
So Jeff, that is to say, if the clause, the FAR clause we're talking about was in your contract, it does not matter how many employees you have. It would apply just as a matter of that clause going in your contract, regardless of how many employees you happen to have.
Right. Next question. If you have a remote employee, are they still subject to provide a negative test on a weekly basis in place of vaccination? With respect to the federal contractor mandate, there is no vaccine, or there is no testing alternative built into the mandate. But I will say that remote employees are required to be vaccinated if they're working on or in connection with a government contract, even if they're working at home by themselves. If they're working on a contract that has the clause, then they are, you know, going to have to be vaccinated.
Jeff, do you want me to
Another
take that
question.
three-part one here?
Which one?
We've got a three-part question, looks like, that I've read through. Do you want me to address
Yeah,
that?
go
one?
for it.
So the question is effectively, the VA has issued a modification that calls for those who are unvaccinated but have medical or religious exemptions to still show negative COVID-19 test results within 3 days. So we're talking about mandating a certain level of accommodation, it sounds like, where the VA is saying, if you give someone these accommodations, you still need to get weekly testing from them. It's likely that's being included because your work is actually at a VA site, but the VA could impose that additional requirement on you. This isn't improper in itself for them to say, if you give someone an exemption, here is more that you have to do in terms of the accommodation. So they could require testing, yes.
Thanks, Casey. Next question was whether material or products that are delivered to the covered site will the supplier or of the materials or products be required to comply with the requirement, such as a concrete supplier. That is a little, I guess, you're still purchasing the, even though there's some delivery service, they might need to be vaccinated to access the site. But I'm not sure they would be required under the mandate to be vaccinated. Do you have any comment on that, Casey?
Yeah, I agree with you. If your contract simply says you're going to provide concrete, this should not be subject, or your contract should not be subject to these requirements because you are simply providing products. On the other hand, if you're a supplier who is also going to deliver and install or something along those lines, you've now crossed over into providing services as well, and it would apply. But as long as it is simply supplying materials, the requirement should not apply.
Okay. I think we're almost to the end here of the questions, which is
Yeah,
good.
there's a last one there about the language received from the government agency.
Yeah, you want to take that, Michael?
Yeah, it's very broad and requires compliance with the task force guidance, regardless of the executive order. The executive order is deemed unconstitutional or further revised, does the modification still apply? No, if the executive order is deemed to be unconstitutional, then the modifications that were authorized by that executive order will disappear. And I would assume that the agencies will take some action to remove those or delete them from the contract.
Okay.
And we've got some more in the chat as well, Jeff.
Yeah, I've covered most of those. Let me just see. One person
Would
asked,
this
John, I may have already asked you this one, but I'll throw it out there again if you want to comment on it. It says, what if someone requests a medical accommodation of time and a religious accommodation?
So it's actually not that unusual for an employee to come forward and say, I want an accommodation and I have multiple reasons. The people who are coming forward requesting accommodations have, I've seen at least our clients have people that proffer both things. I mean, look, we're looking at the accommodation rules, and that could be giving the person some additional time and extension of time, or other accommodations, and really going through the same analysis, regardless if the employee qualifies for one or both reasons, religious and or medical.
Okay, thank you. Another person asked, can you steer us to a suggested medical or religious exemption request form for an employer to use? I don't think we have, John, correct me if I'm wrong, I don't think we have a specific form that we recommend, but as we did mention, the EEOC's form is available online that you can, Google and try to find.
That's right. The EEOC has published this form. I think it did so just within the last week. So that could be found pretty easily just with a Google search.
Yeah. Another question, what is the employer's responsibility in paying for time that it takes to get tested on a weekly basis? Well, first of all, there's that I assume is referring to the OSHA mandate, but I believe I don't think there was anything in the OSHA mandate that addressed whether or not the employer had to cover that cost. And in fact, it's up to the employer's discretion, I believe, whether or not to offer testing as an alternative.
So actually, the OSHA mandate, which of course is on hold now because of the Fifth Circuit, federal appeals court in Louisiana, sort of put everyone on hold with the ETS or the OSHA mandate. But that ETS had rules in it that say that for each dose, each time the employee gets a shot, they get 4 hours of paid leave. And then there's a further requirement that they get leave if they're experiencing symptoms after the shot to recover from it. And that's OSHA has said in their FAQ that they'd recommend 2 days for that. So there is a requirement there in that law, but it's been mentioned now that law is sort of on hold for now, and we don't know what's going to happen to it.
So the question was about time that it takes to get tested as opposed to vaccinated. Do you know anything in there about the employer covering that?
Time to get tested. I'm not aware of anything in the ETS that requires pay for time to get tested. There is a provision that talks about the employer not having to pay for the cost of the test itself unless required by some other state law.
Okay, thanks. Looks like we have two more and then we're going to cut it off. One is if an employee who works remotely, sorry, all right. We've got two more. One, if an employee who works remotely at full-time on a contract, such as HR, and does not want to get the vaccination for no specific reason, what is the company's option?
Well, at a basic level, as we discussed, you could try to provide that person with a time extension, counsel them, perhaps discipline them in accordance with company policy. But ultimately, if under those circumstances, your options would be to remove them from working on the contract so that they were no longer a covered contractor employee, or I guess put them on unpaid leave. John, do you have any thoughts about that?
Yeah, I think that, when you're talking about accommodations, the law tells us there are two reasons that people need to be accommodated. If it's a medical or disability related reason on one hand, or the other hand, if it's a religious reason. For employees who are opposed to the vaccine because of political reasons, because of personal beliefs, or because of fear, we don't have any accommodation requirement there. And so, Casey, you're right that the employer has a lot of discretion with respect to those employees and whether or not we're going to terminate the relationship or put them on an unpaid leave of absence. It's the employer's call. We don't have a legal requirement, though, to accommodate them in the same way as we do for the medical and religious reasons.
Okay, and finally, if an individual has an adverse reaction to the vaccination, who ultimately is responsible if there are long-term effects? Anyone have thoughts on that?
Possibly the manufacturer of the vaccine.
Yeah, if the employer was going to be sued for that, I think you would be about 16th on the list of entities and individuals who would be sued.
Right.
I also think if the employer, if there was a potential tort suit, there would be a strong argument that any such suit would be barred by the exclusivity provisions of the applicable state workers' compensation statute.
Actually, and there's one more, and then we'll call it. And it says, what if you cease installation? I assume that means in protest of the mandate, and I believe the answer to that is you risk getting terminated for default. And
possibly
potentially other
debarred
consequences.
from
Yeah.
government contracting due to a willing and intentional refusal to perform. There could be quite a few negative consequences that come along with that.
Okay,
All
well, listen, we want to thank everyone for your participation. A lot of good questions. We hope we answered some of them. The presentation will be available to everyone. And if further questions come up, feel free to contact any of us, and we'll do our best to help you. Have a good rest of the day.
Thanks, everybody. Take care.